Thank you, Mr. Chairman. I'd like to thank you for convening this important hearing, as well as thanking our witnesses for being with us today. And I'd like to commend the members of the Advisory Council on Faith-Based and Neighborhood Partnerships and its members of the Council's task force for their work. Their recommendations find common ground on which to lay a foundation for strengthening the constitutional and legal partnerships between the government and non-governmental social service providers, as well as provide clarity and transparency in the provision of these services, while all the time protecting our nation's commitment to religious freedom. Unfortunately, their work is far from done. The most egregious aspect of the so-called faith-based initiative, the right of religious social service providers to discriminate in employment with government funds, remains unresolved. One of the founding principles of our great nation was the freedom to worship and not worship as one chooses. Faith plays a central role in the lives of many Americans, and our communities benefit from the countless acts of justice and mercy that faith inspires people to commit. Faith-based organizations are often on the front lines of meeting challenges like homelessness, youth violence, and other social programs. At the same time, the history of our nation and its First Amendment protections do not and should not allow public funds to be used to proselytize or discriminate. In the 1960s, several civil rights acts were passed in order to end the nation's sorry history of racial bigotry. Since that time, it has been illegal to discriminate in employment against protected classes and make job discriminations based on race or religion. And I mentioned protected classes, and I'd like to respond to the gentleman from Wisconsin, the ranking member from Wisconsin, who mentioned the Planned Parenthood example that is frequently used. Position on abortion is not a protected class. There is a difference between Planned Parenthood hiring people based on their position on some social issue, as opposed to we don't hire blacks or we don't hire Jews. Race and religion are protected classes, and that is what is protected in our civil rights laws. One exemption exists for religious organizations, but that discrimination is allowed in the context of a religious organization using its own money. However, long before that, the country recognized the disgusting practice of discrimination in employment while using federal funds. Almost 70 years ago, in 1941, President Franklin Roosevelt issued an executive order prohibiting discrimination by all defense contractors. In other words, if the U.S. government would said that even if you can build a cheaper and better rifle, we're not going to buy it from you if you discriminate in your employment. In 1965, President Johnson expanded that policy in an executive order banning discrimination in all government contracts. No discrimination with federal funds has been the policy of this government for decades, at least until the so-called faith-based initiative. Under traditional laws, many religious organizations have been sponsoring federally funded social service programs for over a century. Until recently, they were funded like all other private organizations are funded. They had to use the funds for the purpose for which they were appropriated. They were prohibited from using taxpayers' money to advance their religious beliefs, and they were subject to laws that prohibit discrimination in employment. Let's be clear, religious organizations could still discriminate in positions paid for with their own money, just not those paid for with federal funds. And many religiously affiliated organizations, such as Catholic Charities, Lutheran Services of America, Jewish Social Services, have been receiving funds, millions and even billions of dollars for decades. Incredibly, the idea of charitable choice and President Bush's so-called faith-based initiative came about because some people insist on discriminating in employment and therefore were barred from federal contracts. They now believe that the prohibition against discrimination with federal funds constituted a barrier that needed to be removed. Unfortunately, the faith-based initiative specifically removed that so-called barrier, and as a result, religious sponsors of federally funded programs are now allowed to discriminate in employment with federal dollars on the basis of religion. That means that a person applying for a job paid for with federal money can be ineligible for consideration for that job solely based on religion. And if this bigotry based on religion is tolerated, racial and sexual discrimination disguised as religious discrimination certainly follows. It doesn't take a rocket scientist to figure out that if you get a pass on religion, it will be impossible to enforce non-discrimination laws based on race. Dr. King once said that 11 o'clock on Sunday was the most segregated hour of America, and that's still true today. And so if you discriminate based on religion, based on which church you go to, that has racial implications. Religious discrimination is also a proxy for discrimination based on sex, based on things like single motherhood, divorce, or premarital sex. It is shocking that we'd even be having a discussion about whether or not civil rights practices ought to apply to programs run with federal dollars. For decades, when funds were raised from all taxpayers, it has been and should continue to be illegal for sponsors to reject applicants solely because of their religion. There's no justification for restoring a practice where you can tell job applicants that we don't hire your kind. The so-called faith-based initiative represented a profound change in policy since 1965. If an employer had a problem hiring the best qualified applicant because of discrimination based on race or religion, that employer had a problem because the weight of the federal government was behind the victim of discrimination. But with the faith-based initiative, we shifted the weight of the federal government from supporting the victim to supporting the employer's right to discriminate. This is a profound change in civil rights protection. And if we don't enforce discrimination laws in federal contracts in secular programs, where is our moral authority to tell a private employer who may be devoutly religious for what he can and can't do with his own private money? A policy of religious discrimination in employment is wrong in the private sector, and it is certainly wrong with federal funds. We need to, unfortunately, the executive order did not address this profound issue. It failed to address the employment issue, and we're disappointed that they failed to present a witness so we could inquire why that was done. Mr. Chairman, I'd like to insert to the record the rest of my statement.
Without objection.
But I look forward to the testimony of the witnesses, particularly in light of the question that we'll have on employment discrimination, and I will yield to the chairman of the committee.